Simon is an expert in probate. He's an expert he does some civil litigation, real estate law. His brother Mark is also on the call, and he is an expert in real estate law as well. So without further ado, Simon, take it away.
Yeah, hi everybody. Thanks for the opportunity to speak to your group. The question I've been asked to talk about today is dealing with a client who died, specifically a client of yours who may have signed an agreement of purchase and sale and then died before closing. What do you do aside from offering your condolences? Quite inconvenient. Whether it's a buyer or a seller, it's kind of the same situation. You have effectively a deal that's binding that needs to close, and yet short of picking up the hand of the deceased and scribbling the signature, it's not going to be able to close here. I don't know how many of you bumped into the situation. For whatever reason, it does seem to pass through my office quite a bit. Maybe it's because I do interact in real estate and the estates world, and they overlap in that way sometimes. So the question, there's always an initial panic about what to do, and the panic is on the part of both the estate and a little bit also on behalf of the agents who call and say, I worked very hard for this deal, and as bad as I feel for the family of the person who died, what do I do about my commission here? What's going on? There's always a lot of uncertainty swirling around. So the goal here today is to talk about some of the basic facts, the basic law that surrounds this particular issue, and what it means for you guys in your commission, kind of how to know if you can close this deal or not, and what may stop you, what the problems may be. I should preface it by saying there's always a bit of uncertainty with a death. I mean, you really all of a sudden open up a situation. It's a bit of a Pandora's box. All of a sudden, all these new family members or potential objectors are brought into the situation. And it really, despite all the information you may have, it may still be that there's, a distant cousin or niece. It's always a distant cousin out there who causes some trouble. But regardless, there's definitely some basic points we can go through that will be very helpful for you guys in terms of at least calming you down if this happens to you and knowing what to do if it does. So really the first question you have to have for yourself is there a will? The will is very important to you. The will appoints an executor. So the executor is the person who makes the decisions for the estate. Okay. That includes what to do about the agreement of purchase and sale. So for example, you could have an agreement of purchase and sale that's been signed. Let's say it's the buyer and there's conditions. Well, the executor can make a decision about those conditions. The executor can say, I don't want to proceed, and get out of the deal, whereas the person who died wouldn't have done that. So speaking to the executor is very important. In addition, at the end of the day, once the executor kind of achieves what they need to achieve, which we'll discuss later, basically gets the estate probated, the executor is going to be the one who's signing off on this deal. So you've put in all the effort to get your client and get this deal, and the person dies. You have to make nicey nice again with this executor, and make sure they're in touch with you, you're in touch with them, and there's a plan in place about what to do with this agreement of purchase and sale. I mean, it's important for you to know if this executor understands these conditions, the deadlines for those conditions, and to ask the executor what they intend to do with regards to those conditions. So that's the first step. First step is find out if there's a will, get in touch with the executor. And you may have all sorts of particular issues with that. I mean, a lot of people aren't willing to necessarily disclose a will to an agent for obvious reasons. But usually you could find out who the executor is. That's usually possible because the person's interested in speaking to you as well. There's a lot at stake and they want to understand the repercussions to going one way or another. If there is no will, which happens to a lot of people in Ontario, it's something called an intestacy. In this case, it really is, from your perspective as an agent, very similar. You're going to move to find whoever is moving to be appointed as executor. So even though there's no one named in the will, there's going to be someone, a close family member or a friend, who's going to be moving to be appointed as an executor. If no one does move to be appointed, then the agreement can't close. But practically speaking, this is one of those nice times when we could really ignore the law on that point, because generally, when you have an asset that's this large, someone's going to involve themselves. I've never seen it not happen, and that will be the person you end up speaking to. So, I don't know, agents I think are not that familiar necessarily, and I'd say the general public as well, as to what goes on when someone dies and an estate needs to basically, we call it be probated. There's a bunch of different terms, get certificate of probate, things like that. It's really the same process for a will or without a will. Basically, what happens is the executor has to serve all of the potential beneficiaries with a notice that they want to be appointed. And they have to tell each beneficiary, if there's a will, what they could expect to receive. And they also have to pay a certain fee to the government, which is really, at the end of the day, a very large part of why this happens. The fee is based on the value of the estate. And this process, so this is kind of a similar process for both wills and when there aren't any wills for the estate, but it's certainly faster when there is a will. And it really has to be done for most estates, especially when there's real property that's involved in the estate and that's selling. There are some exceptions, and it's important to know those as an agent from a mile high perspective, just to generally understand what those exceptions may be. It could be very useful to you in speaking to your, the executor and figuring out whether this property needs probate or not in order to close. Because ideally, what you want to do, what everyone always wants to do with probate, is avoid it. I spend half the time in this office talking to people about how much they want to avoid probate, and everyone tries to do it. And the thing about it that's so attractive is it's actually quite simple to avoid. It's not a complicated tax planning thing that goes into play to avoid it. So it's pretty simple to do in a lot of ways, and everyone's very interested in it. From your perspective as agents, obviously you want to avoid it, because if you avoid probate, you can just close, the original deal can just be closed by the executor as per the date agreed to in the agreement of purchase and sale. So the issue with probate is how long it takes. So when I apply for probate for a client, first of all, it's much better for me to apply with a will than without. It's much easier. I would say to all of you right now, there's a lot of reasons to have a will signed, but one very strong reason is just dealing with the probate office. Even in the best of cases with a will, if the estate is over $150,000, which it always is when there's real property involved, it usually takes me 3 to 5 months to get a probate certificate, and that is being kind. That is being that is kind of, I'd say, 30% of the time. I will never tell anyone that it takes me 3 to 5 months. It usually takes me longer. As a matter of fact, when people retain me, I say to them, you could find a lawyer who will guarantee you getting probate on the first shot, then go with that lawyer. I cannot guarantee it. I get rejections all the time, and the rejections take months. It's not as if they look at the submission on the same day and get back to you the same day. They'll look at the submission, they'll let it sit for a couple of months, and then they'll send you an error message. And they'll be very unclear with what the error message is. It causes a lot of delays. You can imagine the stress that is going on this part of the seller, buyer, and the agents with regards to an agreement of purchase and sale that has an impending closing deadline, and there being the silence and / delays from the court, and really no way to expedite it. It actually used to be that you could speak to the probate courts and you can say to them, I have this APS that's closing, could you expedite? And they'd respond. They've made some sort of internal policy decision this year to not do that. I don't know how actually correct that is. I would actually state it differently. I would say it's much easier to get a probate to happen quickly outside of Toronto. That's my finding. I found that it's easier to speak to clerks in small towns. It literally is a situation where they reprimand you for making a mistake. You're very apologetic and polite, and you talk to them, and they respond as an individual. And I guess maybe it has to do with the intake load at each court. But at Toronto, it's very hard to get that kind of rapport going. So you just end up being a number in the system. And honestly, it can take a year. I've seen probates take 2 years, and you can imagine what's going on with the agreements that are closing as a result. In addition, and there's my little joke there, which explains the current hair situation, but also, it is very stressful to try to get probate if there's large deals waiting in the wings as a result. Also, if the reason why, it's not actually the courts being ineffective. So you should understand this, because understanding the full picture helpful in terms of managing your client. It's not the courts are being ineffective. They're intentionally causing these probates to be delayed. They let them literally sit on the shelves and collect dust. There's either a 1 or 2 step process. It goes through the registrar and then possibly to a judge to approve the order, although the judge is in any event. It sits there because what they're trying to do is give potential beneficiaries or disgruntled beneficiaries or anybody the opportunity to challenge the probate, to say, no, I don't want you to be executor. I want to be executor. Or alternatively, no, I don't think this will is valid. There was a will drafted 2 years prior. That one's valid. This one is invalid. And they always give the same 5 reasons for making it invalid, and they file a notice of objection. And that turns into a state litigation, and that's the kind of litigation that goes on for a while. On the one hand, estate litigation is better than normal litigation. It does have a specific court, and it is handled more, in my opinion, expeditiously than regular civil litigation. But on the other hand, it's litigation, and it could go on for years. So it causes significant in terms of your ability to get that probate to happen. And if you find out that an objection has been filed, then there has to be some discussion, some planning about what to do about an agreement of purchase and sale that was signed and has an impending closing date, because litigation has an unknown basically duration. So basically, the policy decision has been it's just very important to give the potential objectors time to object, and the other repercussions to that, like what we're dealing with here, are secondary. So that's how that's what the court thinks like, and that's what we have to deal with as a result. Like I said, just a couple of things. Like, you should be aware that if there is no will, there are problems that could come up outside of litigation, which delay things extensively. So again, as an agent, you're really much happier if you hear there's a will. If there's no will, if there's minors involved in the estate, then you have government agencies involved, like the Office of the Children's Lawyer. If they want certain orders drafted and signed, it takes a very long time to accommodate them, although they're quite good. They are very fast, but even so, they have their own specific needs and requirements. And also, it's just much more likely to be challenged. The appointment of the executor, the wills. I mean, there is legislation that governs it. It's a Succession Law Reform Act. It tells you who the beneficiaries are supposed to be, but it certainly doesn't tell you who the executor is supposed to be. Although there is a general understanding that usually it's the same order as the beneficiaries that are ascribed in the Succession Law Reform Act. For you guys as agents, the real point is that you have to expect that without a will, there's going to be a greater delay for probate than with a will. And you just have to know that when you're planning on how to deal with, this agreement of purchase and sale that you have that is either going to die or you're going to manage to keep alive by extending and dealing with the other side. So the key things, really the point of this presentation, the real point is to say to you, look, you should know this mile high point that if you have someone sign it and that person dies, you're going to have a problem waiting for probate. You're going to have to deal with that. I'll give you some examples at the end of this, some suggestions at the end of this presentation as to how to deal with that. But that's really the point of it. You should know you have a problem, and you should just get on the horn and start to deal with it. Call the executor, call the other side, figure out what to do. I'll give you some suggestions as to what can be done later on. But right now, you should as well. The second point to this presentation is there are some exemptions to probate. So sometimes you could say, great, I could avoid this probate. I'd like to talk to you guys about how that's possible. There's really 2 ways to do it. The first one on the slide you can see is called first dealings, and the second one is joint tenancy. The second one you're probably familiar with. The first one you may not be. Okay, so the first exemption to probate is basically it used to be, I don't know how much agents are familiar with this. Maybe some of the older agents are. This is already getting, we're getting up to the 30 or 40 year mark here on this. But the property in Ontario used to be in the registry system. It's now in land titles. With that conversion, the government made a decision. I won't go into the details. They basically said, look, if you own the property and we convert you from registry to land titles, and you just haven't done anything with the property that changes ownership, okay, and then you die, then that's called a first dealing exemption. And we will agree that you do not need probate for this property. There's some, there's some complications to that. It has to be that you die with a will. So that's another good reason to have a will. And there's some other things you can see on this slide that, the questions become, what is if it was a joint tenancy? And the person died after it was converted to land titles, et cetera, all these questions. It doesn't matter. From your perspective as an agent, what you need to know is there is this first dealings exemption. And if you have this issue arise where the person who signed the agreement for purchase and sale dies, your client, you should call a lawyer and ask them, hey, I've heard about this first dealings exemption. Does it apply? This is a bit of an old school system. There's no way to digitally know. Someone actually has to pull the parcel register, go through it, and figure out if first dealings apply or not based on what they're looking at. They have to pull up the deleted instruments and go through it. I've had to do it myself before. Okay, things like mortgage don't matter. What matters is transfers of ownership. But even those are somewhat, like I said, with the joint tenancy, complicated. Again, from your guys' perspective, it's just a simple question. Lawyer, does first dealings apply or not? Tell me yes or no. It's yes or no. The second exemption is joint tenancy, which I'm pretty sure most of you are familiar with. So joint tenancy just means that there's, two parties or more on title, and there basically is a right of survivorship. It means that the last person standing inherits the entire property. When you have a joint tenancy, the property does not go through the estate. The will doesn't matter. Okay, well, from your guys' perspective, the will doesn't matter. There's some interesting case law on that, but from your guys' perspective, the will does not matter. Okay? Simply put, if it's joint tenancy and a person dies, the survivor makes a survivorship application and the LRO lets that happen. You don't need probate. You can close the deal. Behind the scenes, joint tenancy is very challengeable. Okay, I put down this case Pecor versus Pecor. It's what started the issue in 2007. It's not actually the case that makes real property like land challengeable, but subsequent cases to Pecor versus Pecor have made it that it's clearly the case that just because an elderly person puts a child on as a joint tenant doesn't mean that they intended for the child to inherit. There's also other reasons. As a matter of fact, the court has found they didn't put the child on for that reason. We don't have to go into, actually, they assume that they put the child on just to help them manage the property. Okay, and that it's up to the child to actually prove to the court and the other siblings that this designation of them as a joint tenant was intended as a gift. Frankly, it doesn't matter from your perspective. If there's a joint tenancy and your client dies, okay, this property can still close. There's a survivorship application that's done. The remaining person on title can close the deal. Great. So you have very basic questions. If you're just to summarize it so far, if your client dies, there's a signed agreement of purchase and sale. Is there a will or isn't there? And okay, do these two exemptions apply? Number one, is it first dealings? Number two, is there joint tenancy? That's it. That's how you're thinking if your client dies. Okay. If it's not joint tenancy, it's tenancy in common. Okay. And you can see from the tenancy in common means that whatever portion of the property is owned by the tenant, let's say it's 50% or 40%, whatever it may be, that's going through the estate. That's going through the will. So you really hope, you keep your fingers crossed that if your client dies, it's a tenancy in common, it's a joint tenancy and not a tenancy in common. So tenancy in common is the problem if your client dies. This is obviously assuming there's more than one person on title. I mean, if it's only your client on title, joint tenancy and tenancy in common don't matter. I'm just talking about if there's more than one client on title. Okay, more than one person on title. So I'm going to pull up some examples of joint tenancy. I'm actually going to do it at the end of the presentation. I'm just a bit concerned about my internet connection right now. So let's see if I can actually do it. If I can, great. If not, give me 1 second here. Basically, agents can go to Geo Warehouse, pull up the information on properties. Lawyers go to TerraView. The difference really is TerraView lets us register instruments, make changes to the property, and you guys are really just viewing the properties. So you can see here, this is the Geo Warehouse for, I just did a random address, 425 University Avenue. And then you can see here, this is some of the details of the property. And this little purple screen right here, this is where you guys can pull up title and you can see if it's joint tenancy or tenancy common. So I don't know how many of you know that Geo Warehouse lets you do that. The issue is it costs you $35, I think. I don't know the prices for Geo Warehouse approximately to do that. But, considering everything at stake, you may want to pull up title and see if it says joint tenancy or tenancy in common. So just to give you guys examples of what these look like, I'm sure you've seen these before. But if you see, I put in red here, under capacity share right in the middle, it says tenants in common, 50%. So that's an example of tenancy in common. So once you pull up the parcel registry, this will say tenants in common. If you see that, you say, uh-oh, I may have a problem. I may be dealing with a will, a probate, a delay. I'm going to have to start calling people and figuring out what to do here. This other parcel register is joint tenancy. It says JTEN. So there, if you see that, you open up a bottle or whatever, and you celebrate because it's very unlikely you're going to be having a problem closing this deal. Okay. There are some other capacities you should know. You don't have, I mean, you're really just looking for joint tenancy or tenancy in common. Anything aside from that, call a lawyer, because it's not going to be clear necessarily. But most of these properties are either individually owned, joint tenants, or tenants in common. Okay. So go back to the presentation. So just a kind of another, this is a basic point. I'm trying to keep it, this is actually, I call it a law slide. It's a legal slide. It's really, I wasn't sure if I should include it. I'm trying to avoid discussing the law. I just want to give you guys the practical steps you need to take if this happens to you, if the situation happens, your client dies with a signed ABS. But I just wanted to make, I thought to myself to make two basic points, because I know there's a lot of common information out there about what it means that, you know, a marriage revokes a will. That was very big always in the legal community, but it's no longer true as of 2022. So you should remember that, because, you know, it means that the will's still there. It's not going to intestacy, which is better news for you if there's a marriage and there's no will done after the marriage. And then I put down a separate point as well. The government is just finding that a lot of people are separating and not divorcing, and that was causing trouble. You had to get an official divorce in order to have rights in the spouse's property, the estate, but that's no longer the case. Separation matters now, and the reason why that matters is, again, you know, people who are claiming rights in the estate delay the probate, and they cause litigation. So, you know, the less contentious things are, the less, you know, potential claims people have, the better. In this case, we no longer have a situation where separated but not divorced spouses are involved. They're gone. They're not going to be making claims. It's not going to delay the probate. It's not going to cause you guys to lose the deal / your commission because of delay. So one thing to know, this can cause a delay in the probate, is that a married spouse has rights. They have rights to all sorts of things. In particular, obviously, marital property. And if you don't have to know a lot of the stuff that's on the slide, but just generally speaking, if a spouse is disinherited, it really doesn't mean much. They're still going to be fighting. They're going to be claiming what's called their NFP, pursuant to the Family Law Act. And so spouses are involved all over the place when a seller dies. You guys know, I'm not sure, you probably know, the spouse, I'm sure you do, the spouse has to consent to the sale of a marital home, even if the spouse isn't on title. The spouse doesn't have to consent to the sale of other types of property, but, you know, you have examples. I'm actually dealing with this right now. If there's a property that's non-marital and it's sold and the person dies, the seller dies, and they're a spouse, then that spouse all of a sudden has a claim. They have a claim. And this, in my situation, the spouse was disinherited, and they have this net family property claim. And what's happening is if you can believe it, there's a signed agreement of purchase and sale. There's actually a lawsuit for specific performance as a result of it. And what's happening is everyone is desperate and to top it all off, the property's going with a power of sale. I mean, it's really something where you look at this guy and you're just like, I'm going to lunch. But when it's all said and done, no one wants this property to really sell by power of sale. Everyone wants it to stay there so this agreement of purchase and sale that's been signed can close. They can't close it because they need probate. But the probate is being delayed because this spouse all of a sudden has an interest in this property, which he didn't have before. When it was just the wife selling, the spouse had no interest in this property. It was non-marital. Now he does. And all of a sudden, even though everyone wants probate to happen, even the seller's on board, the buyer's on board, the agents are all happy. And in this particular circumstance, even the agents are being sued for a different reason. Everyone wants it to happen. This spouse from nowhere is taking his time, and we're not getting any clarity about what's going to happen. And there's a power of sale, and they're in the process, the mortgagee, of taking possession. So it may be that the property sells, and you can't have specific performance anymore. The property sold. and the agent loses their commission. It's going to sell by power of sale to a different buyer instead of the buyer that originally bought it. And all because the spouse came from nowhere. So again, the general theme is if someone dies, you really have to figure out when probate can be obtained. Everything is hinging on that. If it starts to become this litigation or married spouses involving themselves, well, you have to have your eyes open to the fact that there has to be. I'll give you at the end of this presentation the suggestion about what to do. You have to either get that plan in place or basically accept that you may lose the deal on the commission. So moving on, this is just an example, but it's the case I was referring to earlier. So I'll just move on. So we've already spoken about this. It's the basically an intestacy. So this is where there is no will, who's the executor and the beneficiary. And again, the Succession Law Reform Act says who the beneficiaries are. It doesn't say who the executor is, but it's called a presumption of entitlement as to entitlement. And that's the person you want to call it. And presumption as to entitlement is the same list of beneficiaries that are found in the Succession Law Reform Act. So first it's spouse, then it's children, then it's parents, then it's siblings, then it's nieces and nephews. So basically, you want to call the spouse. If there's no will, call the spouse. If there's no spouse, call the kids. If there's no kids, call the parents. That's who you're trying to figure out is the executor. That's the order to go in if there's no will. Okay, so what do you do at the end of the day? I guess this is really why you're all here. If you want to find out what do you do if you have the situation arise, so the client dies, they signed an APS, you want to close the thing, you want your commission. What do you do? Well, what I've done in the past is people are very understanding. That's what I find. Often in real estate deals, if you ask for a delay or for whatever reason, it's very hard to get it. You have to put $10,000 here, and this is the last delay and all this stuff. There's a financing issue or something like that. But when you call a lawyer on the other side, you say, my client died. People try to make it work because, frankly, the court is sympathetic to that. It's a rational reason for there to be a problem. It's not that the estate is not going to have to close the deal. They will, and they'll be penalized if they won't. It's just that it's a reasonable explanation that really the other side would be hesitant to go to for court just because it's, the judge would be sympathetic to it. They listen. What I found is the simplest, most effective way to deal with it is a rental agreement. Right? Basically, you simply say, look, we anticipate probate's happening at this time. Let's get a rental agreement going where the buyer's basically renting for a couple of months, whatever it is, until this probate can be obtained. And in the meantime, we will be copying you on all of the letters we send to the probate court, basically weekly, telling them we need this APS to close. This is what's at stake. And I am a believer that despite this new internal policy that the courts won't respond to the need for an expeditious probate, if you tell them there's potential litigation, significant damages, and all this, if the lawyer writes that and the lawyer is committed, because we can walk into the court, we do this, we walk into the clerk's court, we have to, we go before a judge, we can get it expedited so that it will be a short-term rental agreement at the end of the day, unless there's something extremely complicated about the estate, or there's an objection, or it's actual litigation. But if it's simply just a case of getting that probate, you could expect that rental agreement will only be 3 to 5 months. And then that's what's happened to me in the past. Now, I've had other people who had other complicated issues where they don't want to be a tenant. And then they do things like licensing agreements. There's other things as well, closing and escrow, things like that. But really, from my perspective, what's always worked is tenancy agreement. And everyone is eager to basically close the deal. That's what's always happened to me in the past and make it work in everyone's understanding, which is something very rare in the litigation world. But obviously it's understandable in the situation. So that's what I found practically is the resolution. Okay. And it's important to have a lawyer who doesn't just file the probate. That lawyer has to have either be at the court or have his or her process server at the court, knocking on the door, explaining the need to expedite this on a constant basis. The probate courts themselves, they don't want to be the reason why a deal falls through and there's significant damages. No one wants to be on that short end of that stick. Okay, so I'm going to give you guys just some examples of, so this is actually a different situation. There's two other things I'm going to talk about very briefly at the end. Number one is, what happens if a person dies and before probate, there's a great deal that's coming in, you're working with the executor and the executor wants to sign. Can the executor? Okay, so what happens, this is a bit different. What happens if you want, if you have this great deal as an agent, you want the executor to sign, can they sign? Can an executor sign before probate is obtained? The answer is yes. I get this question asked me a lot. There's some clauses you could put in to the agreement of purchase and sale. As you can imagine, what those clauses are, look, there's probate going on, and we need to agree that if we can't get probate by a certain time, that this closing is delayed until probate is obtained. So I'll pull up some samples for you guys. I have 2 examples of clauses that I've put into agreements that I find very useful. And if you want them, Steve obviously can hand them out to you. Or I think this is being recorded, so you can have those. But that's the answer there. Yes, you can get your good deal to proceed. You don't have to wait for probate. The executor can sign, and then I'll try to pull up the. Okay, so these are the 2 clauses. I mean, it just basically says, I think the second one is better. You can see the buyer and seller agree with the seller on giving a minimum, notice of blank days to the buyer, may unilaterally extend the date for completion 1 or more times, not to exceed a certain amount of days, to be calculated from the date of acceptance of this agreements for the purpose of obtaining a certificate of appointment of a state trustee. So you're basically disclosing the issue. Everyone knows about it. You're giving yourself all the time in the world to delay as much as you need if the probate court is rejecting this thing. And then you get this signed, but you don't show this agreement of purchase and sale to the probate court. You just tell the probate court it's extremely urgent, this has to close. That's all you do. Okay, you don't tell them there's this clause in there that allows the extension. So the last thing that's actually going to be talked about is actually completely unrelated to anything I just said. Steve asked me very quickly to just do discussion about what happens if a purchaser walks away from a deal that's been signed. I think it's practically on the ground. A lot of that's happening right now. I'm certainly seeing it at my office. It's why I asked my brother Mark to show up on this call. Basically, he definitely deals with a lot of this kind of issue, and I'm always hesitant to call my brother an expert, but he's an expert on this one, that's for sure. So I have to say it. So any questions on this, he's here to answer if they get a little bit complicated. But just generally speaking, what I've experienced in my firm about this is, and a couple of things you should know. So the deposit, if there's a deposit paid and the purchaser walks, those are liquidated damages. The seller gets those kind of damages no matter what. The seller can sue for remaining damages once damages are mitigated. After the seller relists and sells, and let's say loses $200,000, they can sue for that. But the interesting thing that I found is that even though the sellers call me and they say, "Aha, I've got the buyer in my sights," and they're completely at fault and the law's on my side, practically what happens is that the buyer actually has no leverage. You guys know you're not allowed to basically release these deposits without a court. I mean, there's 3 grounds to it that always seem to be coming up when I speak to the lawyers on the other side who are representing buyers that are walking. There's a court order is required, or a mutual agreement, a release sign, things like that, or completion of sale. So if you can't get the consent of the buyer to any of those three things, and you're not going to get the consent if you're basically completely litigious and not willing to compromise as the seller, then you're going to court. And a lot of sellers want to avoid going to court. They just want to basically get some money, get as much as they can, and move on. Because who wants to go to court if you could just get damages sufficient to take care of your problem and move on. So a lot of times the negotiations are, you as the seller have this great position, and you could either take what the buyer's offering you now, which is pretty decent, or you can go to court. And you'll probably win, but at the end of the day, what is it you're going to win, and is there going to be necessarily anything to collect on from this buyer? Negotiations, and usually there's some sort of middle ground that's strongly in favor of the seller, but still somewhere in the middle that's reached. That's a compromise. I don't have much more to say about that. So that actually concludes the presentation.
Thank you so much for watching. If you like our video, please hit the like button, the subscribe, and even the little bell to get notifications, just so you can stay in touch and watch more of these great videos.